Hello everyone, this is Advocate Meghana Dhairyawan and I welcome you all to MSD Legal channel. You are watching Know the Law series, and in this episode we are going to discuss the procedure about check bouncing cases and section 138 of Negotiable Instruments Act 1881. I am sure you will immensely benefit from today's episode, as practically in day-to-day life we issue lot of checks and we also receive a lot of checks from various parties during various commercial transactions that we come across. So the Negotiable Instruments Acts deal with the deposit and the recovery procedure as per the check, bill of exchange, promissory notes, hundies, which used to be traded during ancient times, and it is even valid today. So all these instruments which are to be exchanged and to be used for the purpose of payment of consideration under various contracts for commercial reasons. So it has to be used for that purpose. Now let us discuss what is the reason for check dishonor. So mainly the check dishonor happens is because of insufficiency of fund, which is the reason behind action under section 138 of Negotiable Instrument Act. Apart from this, there are also reason for the torn check, or the check is mutilated, or it is defaced, or there is some manipulations which are done on the check, or some overwriting which is done on the check which is not allowed, and then it is not credited to the beneficiary's account. Also, we all know the check is valid for 90 days, which was earlier 6 months, that is 180 days. However, now it is valid for 3 months, which is at the locally issued level. So at any level it is the validity is 90 days. Suppose you have received the check as of 1st of January, it has to be deposited latest by end of 31st March. If you go and deposit that check after 31st March, that is end of 90 days, the check itself is invalid, and irrespective of whether the drawer has the money in his account or no, the check won't get effected and it won't get deposited into the account itself. So this is also one of the reason for dishonor of check. However, for all these reasons, typically drawer is not responsible for dishonor of the check as such. Now let us understand insufficiency of fund. So insufficiency of fund means whenever the check is issued, as I have told you, there is a limitation of 90 days. So during these 90 days, anywhere the check can get deposited by the beneficiary, and in that point of time, if the drawer does not have sufficient fund in his account to the tune of the check amount, then the check gets dishonored by the bank and it is never credited by the bank as such. Now in that case, the depositor, that is the person who is supposed to receive the money from the drawer, is received the bank intimation along with the check, the original check which is deposited by the complainant, that is the person who is going to receive the money. So he receives the bank intimation, and that advice contains the specific remarks for the reasons why the check got dishonored. Now these remarks can be for insufficiency of funds, or if it is a lapse of time period, that is the validity lapse of 90 days what we discussed just now, or if there is a mismatch in amount mentioned as per the words or as per the figures. So these are the various reasons for which the check is returned by the bank. Many a times if the depositor also makes mistake of depositing wrong check, and that is also one of the reasons why the check comes back and check bounces as itself. So we are going to discuss what is the insufficiency of funds and what are the further procedure. So whenever you receive such bank advice for dishonor of check, the first step of any legal procedure under Negotiable Instrument Act is to issue a demand notice. So the demand notice is to be issued to the accused, so who has defaulted the payment, stating the amount of payment, and then you have to give the grace period of 15 days of for recovery, so that he can come back to you and he can repay your money within 15 days. And then you have to clearly mention that if the amount is not received within 15 days, then the check bouncing case will be filed as per the Negotiable Instruments Act. This notice has to be an advocate's notice, so all the technical angles are taken care of and all the necessary elements are mentioned in the notice. Now once that notice is issued, This notice is to be issued within 30 days from check bounce, that is from the date of intimation of bank. So the limitation period is 30 days for the issuing notice. Then the second limitation comes to file the case. After you issue the notice, you give another 15 days of time to the accused, and if within 15 days accused does not pay you check amount either fully or partially, then you can proceed to file a criminal case against accused under section 138. Now to file the case against the accused, you have the another limitation period of 30 days from date of grace period, that is the due date that you mention in your demand notice. So this is the time frame that is given under the Negotiable Instruments Act. Let us understand what is the place of filing for application of check bouncing case. So the place of filing can be a local magistrate case, local magistrate court of place of residence or place of business of either complainant or accused, or also there can be a place of issuing legal notice from where the demand notice was released to the accused. Suppose A is residing at Mumbai and he is dealing with B in a matter, and he goes to the Delhi, and from Delhi if he releases the demand notice, he can also have the jurisdiction in Delhi court as well to file the check bouncing case regarding this matter. So this is regarding the jurisdiction of the check bouncing case. Then comes as to the procedure. So the procedure is very simple and clear. The person has two options in India. Either he can start with the summary suit under order 37 of civil procedure, which is nothing but the civil suit, and it is a shortened procedure under civil law, and he can also initiate the civil procedure as such. And another option is the criminal procedure, which is under Negotiable Instruments Act. The magistrate court, which is the criminal court, handles this trial as per the code of criminal procedure, and then under section 138 the matter is proceeded. So when the matter is filed before the magistrate issues a summons to the accused stating the date and time fixed for the matter, which is the next hearing date of the matter. Along with the copy of complaint, it is delivered to the accused, and accused is supposed to show up on the next hearing date along with his advocate, and he has to file the reply. However, if he doesn't appear before the court even after receiving summons, then the bailable warrant is issued by the court, and it is issued and executed through the local police in whose jurisdiction this person is staying or is doing the business. So the warrant is issued, and if it is not, if even after issuing the bailable warrant, if accused doesn't come before the court, then non-bailable warrant may be issued by the police through the police, and if still he doesn't come, then he has to seek the bail from the court first before providing any defense under the check bouncing case. So this is the overall procedure as far as the compelling attendance of the accused before the court in case of check bouncing matter. Now in 2018 there is important amendment which has come in, which provides for the interim compensation to the complainant, because these cases are on continuous rise and the amount involved in the check bouncing cases is also very huge. So wherein the accused is seem to have these misuse these provisions and to use this trial period as a interest free funds period. So to curb this practice and also to curb the unnecessary burden on the courts of these additional cases, the new amendment has taken place in 2018, whereby the court can grant interim compensation of maximum of 20% of check amount to the accused, and it has to be paid to the complainant within 60 days from such date of order. Now this is very stringent imposition on the complainant, on the accused, and this is only to curb the unnecessary delay that is prolongs the matter, and it is misused by the accused as such. Second amendment talks about section 138, wherein in appellate level, where this trial ends and whether there is a conviction, that means when he is found to be a guilty, then he is the complainant is supposed to receive the money. However, the accused plays his part and he files the ferocious appeals in the appellate court. However, where he is found to be a guilty, then he has to pay additional 20% of the check amount as a fine to the accused. And then this is a penalty which is imposed by the appellate court, which is in addition to the section 143A interim compensation. So this is another check on the additional appellates appeals which are filed, which are frivolous and which are not based on merit, but wherein the accused is just trying to drag the matter and have the prolonged period of interest free funds. So this is the two important amendments which has come in 2018, and that has really helped the judiciary to reduce the burden of these cases. Not only that, only serious matters are seem to be on rise, and the frivolous matters are cut by way of these amendments. Now, wherein the person, that is the accused, is found to be guilt free when it is released from the magistrate court, and when there is a acquittal in the magistrate court, then whatever money he has paid to the complainant by way of interim compensation, so the complainant has to return back that interim compensation amount along with the interest of RBI's current interest rate. He has to return back that amount, entire amount, to the accused, so that this amount as a way of compensation was never due, since there is no charges that could be proved against the accused. So it is a two-way sword. If the acquittal is there, then whatever compensation was received to the complainant has to be returned back to the accused along with the bank interest, whatever was the current, whatever is the prevailing rate of interest as per RBI circular. And if there is a conviction and accused still chooses to go for the appeal, then he has to pay the additional 20% as a fine, which is over and above the 143A interim compensation. So this is a two-way sword. And then let us come to the important element of blank checks. Many a times the blank check is also signed and handed over to another person. However, sometimes amount or date is not mentioned. Only the beneficiary name is mentioned, and the signature is put by the maker, and such check is handed over, which is called as blank check, to the other person. Now if this other person puts the amount or the date and he deposits the amount, and if this check gets bounced, still the liability is same as per the regular check bouncing case for the accused. So there is no difference that it is a blank check and it was never mentioned of any time or amount, and that is the reason why it got bounced. So such kind of defense is not available, and presumption of liability is already considered under section 139 as such. So I hope you have liked today's topic, because it is related to our day-to-day practical life, and I am sure you must have got good insight of the Negotiable Instruments Act. We also have the other topics which are uploaded on this channel, so I request you all to go through the same and share this to maximum of the your network, and also share on your social media as well. Don't forget to subscribe to this channel. Thank you so much. Jai Hind, Jai Maharashtra.